Been a tumultuous and emotional week with the parents of Reeva Steenkamp saying they plan no civil action against the former Olympian Oscar Pistorius for the brutal killing of their daughter. But there is still an avenue that exists for civil action against Oscar Pistorius. This is the MoneyMakers. I'm Bruce Whitfield. Tonight I'm joined by Bernard Hotz. Bernard Hotz is a specialist litigator, and when it comes to issues around civil action, he is an expert in the field. Explain to me this concept of civil action, if you would, Bernard.
Good evening, Bruce. Thank you very much for having me on your show. Bruce, let's look at two concepts in law. The one is called contract and the other one is called delict. For the purposes of this discussion, we need to focus on what's called delict. And I'm going to mention a few words which give you an idea as to the elements that have to be proven in order to succeed in a delictual claim. We talk about an act, we talk about a causation, we talk about a wrongful act that results in damages being suffered. So you don't need to have a contract with somebody. In this instance, we have a situation where the Steenkamps are able to show that Oscar committed an act, which is a wrongful act, for which he has been convicted of murder, and the result of that act has been to cause them to suffer damages. Now we look at what the term damages is. And if, for instance, you look at, as I understand the history to be, that the late Reeva Steenkamp used to help her parents out on a monthly basis. They needed the help. They need the help now. They're able to show to the court that as a result of being deprived of having that assistance from their late daughter, they have suffered damage. And that's the kind of claim, civilly, that one would contemplate instituting in our courts.
Okay, now let's assume for a moment that Reeva had not been financially supporting her parents. Would they be able to institute a civil claim anyway on the basis of the hurt, the deep pain that they would have felt as a result of losing their daughter?
Bruce, the one thing we've got to be mindful of when talking about damages claims is we have a concept in our law which says that the damage that you allege that you've suffered should not be too remote from the cause of that damage. Now, you may turn around and say, well, the pain and suffering that has been inflicted is not too remote. But then we look at what our law says in relation to damages claims. Our law says that as opposed to, for instance, in the US jurisdiction, where we have a concept there called punitive damages, our law says that a party should be in the same situation that they would have been had it not been for the harm that has been caused. In other words, the pain and suffering is, in my view, something that is too remote having regard to the kind of damages claims which our courts envisage receiving and adjudicating upon in instances like this.
Okay, let's move even further into the hypothetical then. I have a family member who is killed in a motor car accident. The fault of the motor car accident was the fault of the other driver. It is proven in court to be the case. I am so devastated, I don't work for 12 months. I lose 12 months of income. Can I sue under those circumstances in terms of South African law because of the fact that it did have not only a deep emotional impact, but there was a financial consequence to that impact?
Bruce, once again, I think that may be stretching it. One has to bear in mind that you can prove the act and the unlawfulness and the causation. But insofar as the kind of damage that has been suffered, the test is to be able to show to the court that as a direct result of that, I have suffered a pecuniary loss for which I'm entitled to hold somebody else liable. So in a case like that, yes, it could be advanced. Obviously, we're talking about hypotheticals. It's going to have to turn on the actual evidence of a particular case and the facts of a particular case.
Okay, so that hasn't necessarily, then, to your knowledge, hasn't been tested in court to that extent. However, we go back to the Oscar case, and we've got the Steenkamps, which have, if they choose to, an opportunity for a civil claim against Oscar Pistorius. Now, for many of us, we would feel appalled at the fact that we would put a monetary value on the life of one of our loved ones. 5,000 Rand a month. They were worth considerably more than that to us alive, and that's where it becomes quite a difficult element of horse trading when it comes to civil claims of this kind, Bernard.
Absolutely. I mean, of course we're dealing with an emotional subject, but once again we've got to look at the law on this. The law says you cannot profit through a damages claim. So you cannot, and it might, you know, if for instance the late Reeva Steenkamp was contributing hypothetically 5,000 Rand a month, you cannot then say, well, I'm entitled to 100,000 Rand a month, because to only claim 5,000 Rand demeans the importance of a human being such as our daughter in our lives. The law says, unfortunately, you can only be put in the situation commercially that you would have been in had it not been for this particular act which has deprived you of that. The other issue which we've got to look at, Bruce, is that we have in our law a concept called prescription. And in this instance, we would be looking at, for instance, a period of 3 years. And without going into the devil in the detail, essentially it says the moment a cause of action arises, or you have knowledge that you actually have a claim against somebody, you have to institute proceedings within a period of 3 years to assert your rights, failing which your claim would prescribe in law.
There's also a question, I suppose, of being found guilty of a crime and receiving a fair and just punishment. And depending on the sentence which is meted out on Oscar Pistorius, the debate will go on long and hard about that. In the case of O.J. Simpson, you'll remember that particular case, I'm sure, Bernard, where he was found to be not guilty of the murder of Goldman and his wife Nicole Simpson, that he then ended up paying a civil claim, did he not, in terms of not an admission of guilt, but being held liable for the deaths.
Bruce, once again, we're dealing with two different legal forums. The one is a criminal forum, where in South African law and also in other jurisdictions, the difference between South Africa and the US is obviously we don't have a jury here. And there's a big debate as to the antics that can be performed before a jury to try and sway them on emotional issues as opposed to strictly legal issues. But let's leave that aside for the moment. On the criminal side, the state has an onus to prove the accused's guilt beyond a reasonable doubt. Whereas in a civil context, the onus is a lower onus. It's on a balance of probabilities. So whilst OJ was not convicted in the criminal context before a jury trial beyond reasonable doubt, in the civil context, which has a lower threshold, on a balance of probabilities, they found that he should be held liable. And the same thing arises here in South African law. The criminal level is beyond reasonable doubt. We know he's been convicted of murder after the SCA overturned, and if they were to pursue a civil claim, there's already been a conviction. Therefore, if you recall the element of the delict of unlawfulness, that unlawfulness has already been determined, and the entitlement to claim in a civil context merely has to be proven on a balance of probabilities.
It's a question then of whether or not the punishment fits the crime. On the one hand, you've got a family that has lost an income. The other, you have a man who carried out the crime. He is guilty of murder, and let's assume he goes to jail for the maximum time, say 15 years, for the murder of Reeva Steenkamp. He gets a double whammy should the Steenkamp family then choose to institute a civil claim. Within South African law, those parallel processes can run.
Absolutely, Bruce. And unfortunately, no amount of money can ever console the families, the Steenkamp family. However, the Criminal Procedure Act itself envisages the entitlement of a victim to receive compensation because of the acts of somebody who's convicted of a crime in terms of the Criminal Procedure Act. So it is always envisaged, and it's not a double whammy. I mean, factually, unfortunately, if the Steenkamps have been rendered financially unable to cope as a direct result of this act, the law says they're entitled to claim damages. Nobody's trying to equate that type of claim or the quantum to try and compensate them for the loss of their loved one. But the law does recognize their entitlement to claim damages.
Do we see this happening in South African courtrooms on a regular basis?
We see it happening, Bruce, and in fact, fairly recently, the Supreme Court of Appeal, in days gone by, the test was really that you had to show that you were indigent before you could assert such a claim. The test that the courts are applying now has moved to say, no, indigence is not a prerequisite. If you can show that you've actually suffered damage, then you're entitled to claim that damage. It's not about profiting. It's showing that had it not been for this particular act, you would have received compensation. There's nothing to preclude that.
There we go. Bernard Hotz, I thank you very much for coming in this evening. He's Director and Head of Business Crimes Practice at Werksmans Attorneys, giving us insight into the potential liabilities faced by Oscar Pistorius on trial. Not on trial, he's going through sentencing proceedings at present in an effort to stay out of jail, or at least have a minimum sentence handed down to him in terms of the crime of the death of Reeva Steenkamp. The Steenkamp family, however, said they're not going to pursue the legal claim against him, which they are perfectly entitled to do, and no doubt there will be those who try to change their minds on this one. My thanks to you, Bernard Hotz, and thank you for watching. Thanks so much for joining us this evening on the Moneymakers. Till next time, bye-bye.